Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Where the heck am I? Well, I am at our beautiful Central Washington location. Yes, it's been a whirlwind tour. Seattle to Chicago, Chicago to East Dundee to Naperville, from there to Aurora, from there to Streator, back to Chicago, back to Seattle, but then over to Spokane and down to Pullman, and now back to Cle Elum, all in 6 days. That's right. Hey, I just want to remind everyone that this video is being brought to you by Sonoran Desert Institute. That's right. Get ready to launch your career in the firearms industry today. Sonoran Desert Institute, arming America through education. All of their information down in the description box. I want you to imagine for a second, America, if this river right behind me happened to be a state line, okay? Now, as I sit right here, I have a First Amendment right to speak freely. I have a First Amendment right to go to whatever church I want. However, could you imagine that if I crossed that river right over there, suddenly I no longer had that right? I also have a right here as I sit to be free from unreasonable government searches and seizures. Can you imagine if I crossed the state line and suddenly I lost that right? Of course, it sounds ridiculous because that's not how constitutional rights work. Unless, of course, we're talking about the Second Amendment right. And then if you want to talk about the right to keep and bear arms, and you have the audacity to cross certain state lines, like into California, well, you absolutely positively do not have that right at all. Isn't it about time that we end that lunacy? I believe it is, and I think there is a lawsuit out there that can start doing exactly that. So today, let's spend a few minutes and let's talk about the fight to preserve your Second Amendment rights, no matter where you are. Okay, America, we are talking about concealed carry, the right to carry a firearm, concealed carry reciprocity, whatever you want to call it. But really what we're talking about is the state of California. And whenever we're talking about the state of California, you know we are talking about complete lunacy. Because you see, in the state of California, unless you are a resident of that state, there is no way absolutely legally possible that you can conceal carry or carry a firearm for any lawful purpose unless you are a resident of that state. So no matter how lawful, how responsible of a citizen you are, when you go to visit the state of California, you will in fact be unarmed. Seems kind of ridiculous, doesn't it? It is ridiculous. And there is a lawsuit out there that is designed to stop this insanity. What am I talking about? I'm talking about the case of Matthews versus City of Los Angeles. The brief that I'm going to be going through today was brought to us by our good friends at the Second Amendment Foundation. In fact, they were kind enough to privately send me a copy for purposes of doing this video. We're going to put a link for them down below so that you can show all the good folks over at the Second Amendment Foundation some love. Now, the Second Amendment Foundation is participating on this case as an amicus party, but they have done an excellent job of outlining what the issues are before the Ninth Circuit of the United States Court of Appeals, which I get gets us all skittish whenever we're talking about the Ninth Circuit. But amicus correctly outlines the issue like this. This case is simple. No historical tradition supports California's modern requirement that peaceable non-residents who are already permitted to carry firearms in their home states submit to a burdensome process to obtain a California license to carry, CCW permit, if they wish to exercise their Second Amendment rights while visiting or passing through the state. On the contrary, laws historically exempted travelers from such local restrictions on the right to defend themselves, while traveling Americans of earlier eras knew that requiring citizens visiting another state to give up their right to bear arms was untenable. And that is what I really want you to understand, America, is that the laws that we see in states like California, and they're not alone, New York has recently amended theirs, but Hawaii is equally as guilty. Yet, not only are they not supported by historical analogs, they're actually contradicted by historical analogs. Because when we go back into the history of the United States, we will see that almost in all instances, a grace period or some exceptions were made for lawful, responsible Americans who were traveling across state lines and yet wished to continue to exercise their Second Amendment right of self-preservation. Now, with the fact that there is really no history that supports legislation like this, how is it that this case is even on appeal? Well, it's on appeal because the lower court just simply, declined to do any type of historical analysis. And that points the amicus party here to point out, as for Matthews, the district court either was unaware of or ignored the substantial historical tradition of giving peaceable travelers more leeway than residents of the state or city they were visiting. The examples of these travelers' exceptions are plentiful, and they date back to the colonial era. In 1686, the province of East Jersey prohibited privately wearing various weapons, but exempted all strangers traveling upon their lawful occasions through this province, behaving themselves peaceably, which is a colonial way of saying, hey, listen, as long as you are a lawful gun owner and you are acting in a responsible manner, you may pass through our jurisdiction and continue to be armed. But America, this is what I really want you to be most concerned about, because what the state of California is doing here is they are taking the bastardized language of Rahimi and saying, well, this is a more modern societal concern, and therefore we need a more nuanced approach, which is more relevantly similar. And they're doing that because the history that they're using to justify these laws are apples to oranges. But they're also doing it because they want the courts to ignore that if we actually look at the history, the plaintiffs are correct here. Most importantly, the Supreme Court recently affirmed that the key question is whether the challenged regulation is consistent with the principles that underpin our regulatory tradition. Here, the relevant principle is that peaceable non-residents get more latitude than residents of a state when it comes to laws regulating public carry. This squares with common sense. It wouldn't be fair for someone just visiting the state or who had only recently arrived, like Mr. Matthews, to demand they submit to extensive permitting process before exercising their constitutional rights, particularly when they have already been vetted by their home state and the chief of police of the city they are visiting was not issuing permits to anyone regardless. But America, what I really, really want you to be aware of, and this is the danger in this case if it goes the wrong way, is that this tact by the state of California to basically say, hey, listen, we need to take a look at more relevantly similar historical analogs, take a more nuanced approach. They're doing that because, like I said earlier, they want the court to ignore history that contradicts the state's position. But if this line of reasoning were to begin to permeate throughout the courts, that well, I know we got old history that says otherwise, but we want to look at more modern history that actually supports this regulation. Here is the big problem with this case then. It is usually the government that argues that its challenge laws need not be all that similar to historical predecessors. For example, in many cases, state governments have argued that semi-automatic rifles can be banned because of historical concealed carry restrictions on Bowie knives, even though possession of repeating rifles and revolvers, which are far more analogous to modern rifles than Bowie knives are, went unregulated in the 19th century. Okay, so if all of that is the case, though, the amicus party very correctly and wisely points out, if such strikingly dissimilar laws can be used to uphold gun laws, then certainly the historical traveler's exceptions, which were meant to protect against a similar sort of legal injury to what Mr. Matthews is now suffering, can vindicate him and confirm his arrest was unconstitutional. So America, I want you to understand that this case is big for multiple reasons. Yes, we need to stop this insanity that for some reason only one constitutional right never transcends a state border. That's the first issue. But the second issue, kind of behind the scenes, for those of you who really geek out, is that the line of reasoning right now, which is being used to justify these laws, could be used to essentially justify any sort of unconstitutional gun regulation for a court that was hell-bent on supporting civilian disarmament legislation. Okay, the case once again is Matthews versus City of Los Angeles. We're going to link it up down below so that you can geek out on the amicus brief for yourself. We will also put down a link down there so you can show the Second Amendment Foundation some love. Listen, if you got any more questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. But if you don't, that's okay. That information is down there in the description box. Maybe you got an idea for a video we should be doing around here. If you do, go ahead and click on that link right there and let us know. It's probably going to be better than any idea we come up with. Maybe you just want to subscribe to our monthly newsletter. The ability to do all of that is right down there in the description box. And then finally, and most importantly, America, let's remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.